You're trapped. You've been separated for 7, maybe 8, even 10 years.
A decade.
Yeah, a decade. The love is gone. That shared life is just over. But you're stuck. Stuck in a bitter legal fight because your spouse won't sign the papers out of spite.
Or because the law itself forces you to wait. And that misery, that human suffering, is exactly what the Supreme Court tried to tackle in a huge 2023 ruling.
Right. We are diving deep into the Shilpa Sailesh judgment today, and this isn't just a case, it's really a clash of two big ideas.
It is. It's the strict written law, the rigid procedures, versus this idea of constitutional equity.
And that equity comes from one place, Article 142. Okay, let's unpack that. We've heard it called the court's superpower. What does that actually mean?
It's the Supreme Court's unique power to do what it calls complete justice.
Complete justice.
Right. So if a strict law, like the Hindu Marriage Act, is causing just undeniable human suffering, Article 142 lets the court step in and say, okay, we need to solve the problem here, even if it means bending the procedural rules.
So it's like a safety valve for injustice.
That's a great way to put it. It's for balancing the equities when the law itself creates a dead end.
So let's talk about those dead ends. The first big one is the waiting period for a mutual divorce. That 6 to 18-month cooling off period.
The dreaded Section 13B.
Yes. What did the court say about that? Can they just get rid of it?
For themselves, yes. The Constitution bench ruled that for the Supreme Court, that waiting period is directory, not mandatory.
Meaning it's a guideline, not an ironclad rule.
Exactly. Their logic was, if the marriage is clearly over, forcing people to wait just breeds more misery. So the court can look at the facts, see it's beyond repair, and just cut the red tape.
Okay, that handles mutual consent. But what about the really explosive question? When one person says no, the idea of irretrievable breakdown, that's not even a ground for divorce in the law book. So how can the court grant a divorce if one spouse is actively fighting it?
This is the real game changer. The court said, yes, we can, and in doing so, they moved away from the old fault theory.
The idea that you have to prove someone did something wrong, adultery, cruelty.
Right. The court basically recognized that forcing someone to stay in a marriage that is, in their words, emotionally dead and totally unworkable is a form of cruelty in itself.
Wow. So keeping the marriage alive on paper is the actual harm.
Precisely. And under Article 142, they have the unique power to recognize that reality and end the marriage.
That's powerful. But if they're ending the marriage, what about all the other legal battles that go with it? I'm thinking about things like Section 498A, dowry harassment cases, or domestic violence complaints.
A crucial point.
Can the court just wipe that whole slate clean, too? Isn't there a risk of dismissing serious claims just to close the file?
It's a risk they are very aware of. But yes, the ruling confirms they can quash those related proceedings to ensure complete justice. The goal is to end the entire litigation war.
The whole war, not just one battle.
Right. If those cases were filed as ammunition in the marital dispute, the court can end them all at once, so neither person can keep dragging the other back to court for years.
Okay, so this all sounds like a major shift. What does this mean for you, the person listening? Can you just walk into your local family court and ask for a quickie divorce based on this?
No, absolutely not. And this is the most important takeaway.
This isn't a shortcut.
Not at all. This power is exclusive to the Supreme Court under Article 142. The high bar is, well, very high. They're looking for proof that a marriage is truly beyond salvation.
So what's the proof?
Usually a long separation. We're talking 6 years or more. Multiple failed attempts at mediation. And, critically, that the financial security for the wife and any children is completely taken care of.
So it's relief for the truly hopelessly stuck.
Yes. Not an easy exit for everyone else. It's about prioritizing the right to move on when a legal process itself becomes the punishment.
It acknowledges the human reality of a relationship that has, for all intents and purposes, ended long ago.
Exactly. It puts that human misery front and center. But it does leave us with a fascinating question to think about. Does this power, this ability for the court to step in and override laws made by Parliament, provide necessary fairness? Or does it give the judicial branch, maybe a bit too much power to write its own rules? It's a delicate balance.